All right, good afternoon. Once again, it's Wednesday, June 24th, 2020. This is the Economic Justice Law Review Weekly Scholarship Digest here where we present scholarship that's gather scholarship that's been published in the major law reviews and journals around the country, as well as freestanding and independently or I'm sorry, market published books on race, economics, and the law. So we don't publish original scholarship here at the Economic Justice Law Review. We are the repository for scholarship on race, economics, and the law. And it doesn't necessarily have to specifically state economics and the law. What we're doing is proving or showing or recategorizing all racially subordinating dynamics in terms of economics or in terms of the ways in which those racial, micro, or even macro aggressions denigrate the market. How it makes what the framework we're working with is that racially asymmetric market failures and imperfections promote the racial wealth gap. What are racially asymmetric market imperfections? All right, well, if you're talking about neoliberalism, if you're talking about capitalism and racial capitalism and whatnot, let's start with the fact, or at least the idea, that capitalism, or a free market, a perfectly free market, the one that Gary Becker argues will get rid of racism, the market that's talked about in academic circles that will do X and Y based off of the numbers. That market assumes that everyone is a profit maximizer, number one. Everyone there is perfect competition, number two. That everyone can enter any marketplace they choose or leave any marketplace they choose. Number three, that fair, and meritocratic market requires that there be perfect information. Everybody knows everything about everything and everybody. And also, there's no transaction costs in this perfectly fair and free and non-racist market. We know that in the real world, everyone is not a profit maximizer. Everybody's not going to sell their child for the right price. That there is capital needed to enter into markets, and there are things that keep people within markets that don't serve them. Information, please. We can talk the faulty information that's out there that needs to be regulated, that is regulated, is immense. And then, of course, when transaction costs, there's taxes, there are societal externalities, pollution, crime, accidents with respect to torts. And so all of those things mean that the market is imperfect. It's also racially asymmetric, right? The imperfections in the marketplace are racially asymmetric. So there's racially asymmetric market competition, racially asymmetric profit maximization, racially asymmetric information in terms of information about black people and available to black people. Racially asymmetric transaction costs and society's externalities. So that's the framework. We're taking scholarship each week, about 3 pieces a week, and recharacterizing the theme of those articles in terms of how they denigrate an idyllic or a fundamentalist free market, the one that doesn't exist. So in order for there in fact to be capitalism, we would have to true capitalism, if that's what you want to call it. In order for there to be a free market, we would have to solve racism. So it's backwards. Gary Becker argued that a free market, the market will eliminate racism. That's backwards. You have to eliminate racism to have a claim to a free and meritocratic, opportunistic land of opportunity market. All right? So let's get to the scholarship. The 3 pieces that we're presenting this week, Gabbidon of Penn State Harrisburg and Higgins of Louisville are on consumer racism, right? We can represent that as racially asymmetric market rationality, racially asymmetric competition, information, and transaction costs. Consumer racism, you wouldn't think, of course it's commercial and it's economic, but you would think that the inability to spend money would not widen the racial wealth gap, but it does, as we're going to explain in a second. That's Shaun Gabbidon and George E. Higgins, Shopping While Black, Consumer Racial Profiling in America. And that's a book, as a matter of fact, published by Routledge, 2020. The second piece is Matters, from the Washington Bar Association, Mattera, Matters. Got Black Lives Matters on the mind. So Molly Mattera from the Washington Bar Association, Civil Rights Division, on voting rights. And voting rights can be characterized as racially asymmetric transaction costs in the market for goods and services, but also we're going to twist on that, and in a public choice theory respect, going to say that that also represents racially asymmetric market competition. That's Molly P. Mattera, the Shaw claim. Shaw, Shaw versus Reno. The rise and fall of colorblind jurisprudence in 8th volume of Seattle Journal for Societal Justice. Let me correct that. 2020, and third, Hunt, Cecil J. Hunt, from John Marshall, UIC's John Marshall, on incarceration and the racial wealth gap. Or as I would say, again, it spans the commodification of black bodies, or Feeding the Machine by Cecil J. Hunt, commodification of black bodies from slavery to mass incarceration. It's in the 49th volume of the University of Baltimore Law Review, page 13, and it spans the whole rubric of economic deprivation or racially asymmetric market failures. It represents racial asymmetric transaction costs, racially asymmetric information, racially asymmetric competition, and racially asymmetric profit maximization or rationality. We'll explain it a little bit further. Now, before we go on to featuring those three pieces, let me just remind you of some of the stuff that we talked about last week, just in case you were on the brain like, dang, I wanted to download that and get it. Remember, we talked about Camille Gear-Rich out of USC, has a hot played out. Contracting Our Way to Inequality, Race, Reproductive Freedom, and the Quest for the Perfect Child. Really interesting stuff about assistive reproductive technology. Pauline Kim out of Washington, St. Louis, talking about manipulating opportunity. And again, this is an interesting theme, these algorithms, the new Jim Code, as Ruha Benjamin described it. Similarly, Deborah Hellman, Measuring Algorithmic Fairness, in the UVA Law Review. Both of those were in the UVA Law Review because this discussion of technology and how racism and structural racism will be perpetuated in respect of technology and artificial intelligence. Really, 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 really hot stuff, especially in terms of how the law deals with it. I won't go through the whole list of stuff that we did in previous weeks. Jedediah Britton Purdy's work, Camille Lamar Campbell, Denise Berry, Andre Perry's work, a great piece, The Black Cabinet by Jill Watts, Benjamin Idleston, Issa Coleman Hausman. Every week we're just going to keep coming with more articles published in the top law reviews or anywhere that reflect on race, economics, and the law in an intelligent way. We characterize it in terms of racially asymmetric market failures. All right, ready to go? Let's talk about these papers that we had this week. Gabbidon and Higgins on consumer racism as racially asymmetric market rationality, competition, information, and transaction costs. I think this is the first paper we've talked about with respect to consumer racism and how it not only reflects a microaggression and indignity to that individual person, how it contributes to the denigration of a otherwise or idyllic free market, and how that will perpetuate and exacerbate the racial wealth gap into the future. So I describe it as such. Although consumer racial profiling does not by itself widen the wealth gap, it perpetuates structural racism and economic subordination because it denigrates the structures of the marketplace, thereby widening the racial wealth gap indirectly. Didn't I just say that? Yeah, I guess I said it twice. CRP, or consumer racial profiling, is largely based on the myth of black inferiority, i.e. hypercriminality. And so that represents racially asymmetric market information in terms of faulty or untruthful information about black people. Exclusion from individual marketplaces constitutes racially asymmetric market competition. Maybe not as just as much as getting refused or hiring at a job or something like that. The psychic cost of consumer racial profiling with respect to even a successful transaction represents racially asymmetric transaction costs. In other words, the fact that we have to pay more for the goods and service that we want, even if it's a psychic cost. We also know that when it comes to pricing and targeting and whatnot, there is an extraction there as well. Commercial microaggressions like consumer racial profiling tend to discourage. It's one of those things that just drives black people crazy, and especially crazy at meaning wanting to withdraw from this entire marketplace, and therefore it tends to discourage black people from engaging with the market entirely. That withdrawal represents racially asymmetric commitment to profit maximization, right? All right, so let's hear from the words of the book, or a description of the book from the authors themselves, or at least from their publisher. Shopping While Black, Consumer Racial Profiling in America lays out the results of nearly 2 decades of research on racial profiling in retail settings. Gabbidon and Higgins addressed the generally neglected racial profiling that occurs although there is no existing national database on shoplifting or consumer racial profiling from which to study the problem, they surveyed relevant legal cases and available data sources, right? Very quantitative. This problem clearly affects a large number of racial ethnic minorities and causes real harm to the victims, such as the emotional trauma attached to being excessively monitored in stores and, in the worst case scenarios, falsely accused of shoplifting. These two are criminologists, as a matter of fact. Their analysis is informed by their own experience. One co-author is a former security executive for a large retailer, and both are black men who understand firsthand the sting of being profiled because of their color. After providing an overview of the history of CRP and official and unofficial data sources of criminological literature on this topic, they address public opinion polls as well as the extent and impact of victimization. They also provide a review of CRP litigation, provide recommendations for retailers to reduce racial profiling, and also chart some directions for future research. Now, I looked these guys up. They've worked together before. One's at Penn State, Harrisburg, the other's at Louisville. And I find it very interesting, real quick, that they wrote a paper in 2014 with 2 other scholars, Black Supporters of the No Discrimination Thesis in Criminal Justice, a portrait of an underground segment of the black community. Wow. Which a lot of us would have read this before we saw the rise of Donald Trump and the brothers and sisters that support it, right? And not just support the policies. I kind of think I understand low taxes and all that, but why, for those that are enthusiastic about not just the policies but the personality, I don't get it. Anyway, the second paper we're talking about today, or the second article we're featuring, is Mattera, The Shaw Claim, The Rise and Fall of Colorblind Jurisprudence. It's in the 8th volume of the Seattle Journal of Societal Justice, page 25. The Shaw Claim, let's hear from the author first before I start describing them. I think we'll start doing this. Let's talk about what the author says and describe the paper first before I start telling you what I think about it. The Shaw Claim, The Rise and Fall of Colorblind Jurisprudence. First of all, the author starts off, justice is not blind, nor should it aspire to be. And let me just pause there, because most of you know, or some of you may know, that I consider myself an Afrocentric law scholar, and therefore I have affection and appreciation for the goddess Mat as the goddess of truth, justice, balance, and order. And in contrast with Lady Liberty or justice as represented in the Western world, Mat's eyes are wide open. So let me just put that out there. Anyway, back to the author. Why return to Shaw versus Reno in 2020? For the past 3 decades, the principles of Shaw v. Reno have supported a movement to dismantle our most revered human rights legislation, the Federal Voting Rights Act and the 14th and 15th Amendments. This movement was foreseen by a watershed of scholarship preceding Shaw v. Reno on its absence of a coherent legal theory of injury to justify standing, its unprecedented factual vacuum, and its perverse distortion of the Equal Protection Clause. Strong words. With the rise of presidential lawlessness, a surge of voter suppression laws, a sharp increase in hate crimes against communities of color, immigrants, and sexual minorities, human rights abuses against refugee children, and the ever-present reckoning of climate change and capitalism, now more than ever, it's time to examine the causes and conditions that got us here. To do so, we must first acknowledge and then reevaluate the underlying judicial principles that no longer serve us and actively work injustice, one of which is colorblind theory. Now, this paper is very reminiscent of that paper we did a couple weeks ago on the 21st century synthesis. That's Jedediah Britton Purdy, Devin Singh Grawal, Amy Kopczynski, Kay Seville Rachmana. They're at Columbia, Berkeley, Yale, Brooklyn, respectively. Their paper was Building a Law and Political Economy Framework Beyond the 20th Century Synthesis. That was published in the Yale Law Journal. This is upon the same matter. You could also check out Paul Malika's Reconstruction from University of Washington. I forget the journal he published in. It might have been Colorado's journal. But also talking about the jurisprudential ways in which the court is actively supporting neoconservatism and the subordination of black folks as a permanently subordinate class, or caste, if we're going to use the words of, let's say, Isabel Wilkerson in her new book coming out. All right, so talking about this history and linking it to capitalism and the marketplace, again, I've given my critique, or my endogenous critique of capitalism. I understand this person, and also Cecil Hunt, and I understand the exogenous critique of capitalism. But however, to the extent the argument is not necessarily to entirely dismantle it, the question we have with respect to it is how to deal with it. And I would argue that the endogenous critique is the one that is probably going to be a little more effective, but that's just my opinion. All right, but let me describe her discussion of the voting rights in economic terms, neoclassic economic terms, if you will. So voter suppression can be reflected economically in terms of the unnecessary formal and informal costs imposed on the franchise, i.e. poll taxes, or racially asymmetric transaction costs. You can do it in two ways. In respect of public choice theory and the concept of a market for law and regulation. In other words, we talk about the market for goods and services a lot, but there's also these analogies. You've heard of the marketplace for ideas, right? That ideas formulate and become truth through the process of competition, right? And so we could talk about the market structures of the marketplace of ideas. We can talk about its imperfections, and we can talk about how it's racially asymmetric and perfect. And so also, if we talk about public choice theory, conceives of law and regulation as a competitive process, that there is a market for law and regulation, and you got to mass your forces and compete to acquire it. So if there is a market for law and regulation, then voter suppression and poll taxes of that sort now look like racially asymmetric market competition in terms of capital gaps, the vote being the ultimate in capital, right? And therefore the inability or the disparate distribution of that capital exacerbating and reifying racial subordination. Okay. Right? In respect of public choice theory and the concept of a market for law and regulation, formal and informal poll taxes of all types represent racially asymmetric market competition, as well as racially asymmetric profit maximization to the extent voter suppression discourages black folks from engaging in the political marketplace at all. Right? So on top of the fact that some people believe that there's no point in voting because there's no difference from the parties, we know that total disenfranchise is removing black folks from this market. On the other hand, voter suppression can also cause some black folks to just withdraw, right? Through either intimidation or frustration or the petrification of the notion that this country is just not for us, right? All right, so she talks about history, the whole history emanating from Shaun versus Reno. It's funny because I often cite Bob Jones as a landmark case within our history that earmarks a transition from the civil rights era to this neoconservative era. And I guess her argument is Shaun versus Reno is either an additional or a more poignant road marker. All right, on to our last piece. This is Hunt from John Marshall, Cecil J. Hunt, Feeding the Machine, the Commodification of Black Bodies from Slavery to Mass Incarceration, 49th volume of the University of Baltimore Law Review, page 313. And the title immediately struck me, Feeding the Machine, because my argument in Taxes, Death, and Trouble is that Starve the Beast tax cuts required the machine or the beast to eat our young, our Mike Browns, our Joyce Carnells, our Corinne Gaines, our Breonna Taylors, right? Our George Floyds. All right, and so feeding the machine, the commodification of black bodies from slavery to mass incarceration. This article examines the historic scaffolding that was conceived of and deployed to exploit and control black bodies for white profit, from slavery through convict leasing and then to mass incarceration in private prisons. So let me argue that all three of those, economically speaking, slavery, convict leasing, mass incarceration to private prisons, those are 100% taxes on black labor. That's the easiest way you can recharacterize them economically and show how they exacerbate the racial wealth gap. All right, now back to his point. This linear structure helps to expose and contextualize the profit machine that continues to be hidden through this day by political and societal shadows, even as it churns out massive profits for whites. This paper is organized into 5 parts. Part 1, the introduction, presented a brief preview of the topics discussed in the body. Part 2 examines the history of slavery from its beginnings in 1619 to the massive national international dominance of American cotton in the 19th century, to the development of American slaveocracy of the late 1790s up to the end of the Civil War in 1865. And once again, my argument is that we can tie it's a shame and a crime, but it is also economics to the extent we understand that not only was slavery a 100% tax on black labor, the slave owner was then taxed on their income, on their property. They were taxed on every transaction from buying, selling, insurance, storage, warehousing, you name it. So over half of the antebellum states' state revenues were based on taxes on slavery. And then they were spent on anti-poverty programs, of course, with whites being exclusionarily the benefits. Exclusionarily a word? I'm just going to use it on that one. Exclusively the beneficiaries. And then again, we can recharacterize Jim Crow, slavery, convict leasing also as a continuation as a 100% tax on black labor, and therefore this school-to-prison pipeline, mass incarceration, and the policing for profit, which I don't see here, but I think we should also make a reference to policing for profit. These are all ways in which to perpetuate this nearly 100% tax on labor if we can't get to the other ways, right? Sin taxes, fines, fees, forfeitures, any way we can shift the wealth gap from black to wealthy and white to poor and black. Now again, he focuses on capitalism. To me, we're talking about white supremacy, because white supremacy will use capitalism, it will use socialism, it will use communism, but that's a whole discussion for another day. Part 3 analyzes the brutal and widespread impact of the black codes and the symbiotic offspring convict leasing, which former slaves described as worse than slavery. Part 4 examines the centrality of mass incarceration to the entire law enforcement system and the corrosive effects of the commodification of black bodies on every aspect of the black inner city communities. Part 5 examines the symbiotic rise of the multi-billion-dollar private prison industry and its connection to the financial heart and soul of the modern American industrialized, commercialized state. I would hope it makes a great point about, again, that the point of even policing for profit is to save wealthy white folks on their taxes. So as we talk about the state, it is my belief that we should be even more specific and distinguish between neoliberalism, which tolerates and maybe even facilitates racism and economic subordination of black people, versus neoconservatism, which actively seeks to subordinate black folks through the market, and whether that market be the reduction of government or the increase in government. As this shows, it can go either way. Neoliberalism usually talks about the reduction of government towards our detriment. However, we see through criminal justice that is the increase of government power towards our detriment, and therefore I would consider that more neoconservative. This paper is well within the tradition highlighted by Michelle Alexander's The New Jim Crow, which was 2010. It's amazing that was 10 years ago. Other books, James Foreman's Locking Up Our Own, Angela J. Davis, Policing the Black Man, and compare and contrasting that with Andrea Ritchie's Invisible No More, police brutality with respect to black women. Also, again, practitioners are also on the scene. Ben Crump's Open Season. So shout out to all the lawyers, whether you're in academic towers, you're in law firms, or you're independent, like the brother Michael Coard or Michael X in Philadelphia. Shout out to brother Michael X. To all those that are fighting criminal justice, know that we understand the relationship between that racist, criminal injustice, law enforcement, and economic subordination. We can describe clearly how discriminatory racial policing exacerbates the racial wealth grab, how it denigrates the free market and steals away any claim that America has to a meritocracy or the land of opportunity, unless we want to get serious during this time and fix it. So let me close out with that. There's a lot of corporate and overtures to black people after the George Floyd killing and the protests and the rioting thereafter. However, it's very much disappointing and suggested that we're talking about the illusion of inclusion instead of real inclusion, to the extent Aunt Jemima and Uncle Ben are taken off of commercial products, and yet we have heard nothing about the reversal of Citizens United, nothing about the legislative reversal of Shelby versus Holder, nothing about the legislative reversal of Comcast versus NAAOM or the Byron Allen case. We can go through several other cases and other legislative other judicial backwardness and retrenchment that we've experienced over the last 35 years that could be resolved through legislation, but yet it seems that it's not on the table. I don't hear any much of that from the particular candidates. So with that said, again, 3 great papers that we are excited about, or we think you ought to be excited about, that represent racial dynamics that we can recharacterize economically as racially asymmetric market failures and imperfections that perpetuate and exacerbate the racial wealth gap. They are Shaun Gabbidon and George Higgins, Shopping While Black, Consumer Racial Profiling in America, Molly P. Mattera, The Shaw Claim, The Rise and Fall of Colorblind Jurisprudence, and also Cecil J. Hunt II's Feeding the Machine, The Commodification of Black Bodies from Slavery to Mass Incarceration, and the University of Baltimore Law Review. All right, so that concludes our little podcast for this week. We'll see you next week, and remember, cash rules everything around me. One next week. Andre Smith signing out. Did I even say that from the beginning? Andre Smith, Dre Smith, Florida International, Widener, Howard, Penn State. Check you out next week. Economic Justice Law Review Weekly Digest.